Good morning, everybody. Thank you very much for joining us this morning. My name's Peter Blake. I head the construction team here at Pritties, and I'm joined today by my partner, Graham Mead. We're going to talk about the famous Bresco and Lonsdale decision and its practical implications for those who are involved in bringing or defending claims in the construction field by insolvent companies. I will deal with some of the adjudication points, and Graham will focus on insolvency, and then we'll focus a little bit on utility to see how a liquidator might use adjudication in practice to useful ends. So firstly, the adjudication points. Perhaps just remind ourselves of the facts of Bresco. I'm sure most people are familiar with them. Bresco was an electrical subcontractor for Lonsdale. The parties fell out, both accusing one another of breach of contract. Lonsdale claimed the cost of engaging a replacement contractor to do the works that Bresco hadn't finished. Bresco claimed cost of value of works undertaken and damages for repudiatory breach of contract. Bresco was in liquidation, referred a dispute to adjudication, and Lonsdale successfully injuncted Bresco from continuing with the adjudication. There was an appeal that was unsuccessful, and the case ended up in the Supreme Court, who, as is their job, very ably created a nice interface between the worlds of insolvency and construction law or adjudication law, where people had thought previously there was an insoluble conflict. So how did they do this? The arguments that were put forward on behalf of Lonsdale were two, basically: jurisdiction and futility, or utility as it turned out to be. The jurisdictional point was where the clash between the law of adjudication and insolvency was thought to arise, because when a company goes into liquidation, by operation of law, insolvency set-off applies, so that an account has to be taken of mutual indebtedness between the company and any creditor, and the net balance is the amount that is due either way. Now, adjudication, obviously, the jurisdiction of the adjudicator is set by the notice of adjudication, and the argument went that a claim under a construction contract, which is what can be, or a dispute under a construction contract, which can be referred to adjudication, was extinguished by the insolvency set-off, and therefore there was no longer any jurisdiction for the adjudicator to decide disputes under construction contracts where the company was in insolvent liquidation. The other argument was that in any event, even if the adjudication went ahead, it was, to use the words of the judge that have resonated with everybody, it would be an exercise in futility, because, as we all know, the courts will not ordinarily enforce an adjudication decision in favour of an insolvent party, and therefore the thought was, well, what's the point of adjudicating if the ultimate goal, enforcement, isn't going to be achievable? So what did the court decide? The court decided that there is actually no conflict between insolvency law and adjudication. The claims under construction contracts, disputes under construction contracts, are not eradicated, they don't melt away just because the company's in liquidation. They still exist for the purposes of adjudication and can still be referred to adjudication, despite the fact that the bigger picture is that there is a mutual set-off, and all monies due to the company in liquidation are reduced by any monies due from the company in liquidation by the party with whom the dispute exists, and the net balance is the sum that is ultimately payable. So why, going on to the futility or the utility point, the court was influenced heavily by the fact that the statutory right to adjudicate is a right to adjudicate at any time. So either before the contract has been concluded, adjudication, as we all know, was originally conceived as a remedy for to keep cash flow going while a contract was in the course of being performed, and avoid cash flow problems to parties who weren't getting paid. So you can adjudicate at any time, and any time means before a liquidator is appointed or after a liquidator is appointed. There's nothing in the Construction Act or the scheme for the scheme that prevents an a liquidator from referring a dispute to adjudication, and the court was heavily influenced by that. It's a statutory right, and the courts will be very slow to intervene in the exercise of a statutory right. This is really a ringing endorsement for not only adjudication but for ADR generally. There are passages in the judgment of Lord Briggs, who gave the lead judgment with which everyone else agreed, that sing the praises of adjudication as being a cheaper, less expensive, and generally accepted way of resolving construction disputes of all shapes and sizes. He also gives mentions in dispatches to other forms of ADR, mediation, arbitration, expert determination, and even something called early neutral evaluation, which in my experience is fairly rarely used. But this is another decision in the stream of cases where the courts back adjudication up to the hilt, and it's part of the broader policy to try and keep as much dispute work out of the courts, get it resolved by other means. And importantly, as far as utility was concerned, not only did the court say that resolution of disputes is an end in itself, but that enforcement is certainly not the only useful end to adjudication, and that in the case of a liquidator who has many tools in his armory to be used flexibly as circumstances dictate to resolve situations and achieve quantification of the insolvency set-off, there are many good uses to which an adjudication decision can be put, which Graham will have a look at, and we will consider at greater length in due course. Graham, over to you.
Thank you, Peter. Good morning, everybody. As Peter said, I'm going to deal really more with the insolvency aspects that are raised by Bresco this morning. I thought I'd begin, and I know we've got a couple of insolvency practitioners in the audience, but I thought I'd begin, apologies, by giving an overview of how a litigator might perceive this. Now, a liquidator has a number of duties, but I've set out what I consider to be the sort of three that are applicable here. One, they have to assess the debts of the insolvent company and decide which are paid, which aren't, which are part paid. They have to gather in the assets of the insolvent company, and basically they're under a duty to seek to maximize the return to the creditors. So that gives their mindset, I think, when coming into liquidation and a big part of their role. So in that context, Bresco is a fantastic addition to a liquidator's armory. It's a great weapon. On a more simple level, it enables a liquidator, who's obviously not necessarily going to be a construction expert, to ascertain the merits of a claim and whether it's worth pursuing or letting go. If there is a cross claim and the adjudicator's decision has decided both sides, well, even better, it kills two birds with one stone. And going back to Peter's point about its use, it removes, as it were, a lot of the arguments. I want you to pay this money. Oh, I don't think so because I've got a big counterclaim. The adjudication decision will let you cut to the nub, and I think that's positive. And I think, again, it enables the liquidator to have a bargaining chip. It's a bargaining tool to put pressure on the solvent party to pay. And even if there is resistance, and even if there isn't 100% recovery, the fact that it's now on the table, where arguably it was a little bit sort of hit and miss before, is still a positive thing. Even if the liquidator were to say to the other side, I'm going to go through an adjudication, or I have this decision which I'm going to enforce, the headache of it may lead to some form of nuisance payment being made. It is helpful. Going back to Peter's points about ringing endorsement of adjudication ADR in Bresco, for those of you that have had the pleasure of sitting in on a number of my talks previously, I always bang on about how the court gives sanctions to parties that don't seek to cooperate, parties that don't seek to settle. And for those of you that have experience of litigation, you'll be aware of mediation and Part 36 offers and Calderbank offers. And these are things which, if not accepted or refused unreasonably, can lead to serious cost sanctions. So again, what I potentially foresee around the whole Bresco scenario is you may have an adjudication decision or a threat of adjudication, and you couple that with a Part 36 offer or with an offer for a round table meeting or something similar, and you try and exert this additional cost pressure that the court will give you to leverage what you have. So all in all, it's a great way, really, a great way to put pressure on the other side for the liquidator to try and push things forward. However, with my sort of hardened, calloused litigator's hat on, there are various challenges to the liquidator. Bresco could be seen in some lights as being potentially a damp squib. And these really revolve around the following areas in relation to seeking to still enforce the adjudication decision in the court, the issue that Peter touched on of the right of set-off that the solvent company has against the insolvent company. Protections were put in place in a case called Meadowside recently, which some of you will be familiar with. How does a liquidator fund the scenario? And if he does fund it, how will he be able to comply with the court funding rules on champerty and maintenance? So I'll touch on these as we go forward, and just by way of housekeeping, using this as my agenda, there'll be a few extra points at the end which I'll cover. So to begin at the beginning, much of the debate in relation to these cases has revolved around Rule 1425 of the insolvency rules. And broadly what that says is that where there's mutual dealing between, as it were, the insolvent company and its creditor, the solvent company, the liquidator has to take an account of both sides. So it looks at both sides and it sets them off against each other. So if we have a claim of 100,000 by the insolvent firm and we have a claim of 50,000 by the solvent firm, we have a set off of 50,000, which then either proves in the winding up or is pursued potentially by the liquidator against the solvent company. Now, the court takes this set off, this protection of the solvent party, very, very seriously. Why should a solvent company be forced to pay an insolvent company when it itself has no real ability or possibility of recovering that money from the husk that is the insolvent company? And this is where the futility point really kind of reached its zenith. There had to be a fair system of dealing, and there's a great deal of concern over the solvent party losing its rights. So taking my agenda in turn and looking at cross claims and set off first, if there is no set off or cross claim, well, then the insolvent company is probably in a stronger position. It only has to worry about its own claim, and if it goes to court, it may have to give security for the other side's costs, but you are really only looking at, as it were, pursuing your version of events, and you already have technically a net scenario. But if you're facing a cross claim, well, what happens then? Well, obviously, if they're both covered in some form of adjudication, or they've perhaps been dealt with by way of some part of the JCT mechanism, you could argue that it's already been decided. So what's the problem? But I don't think, again, going back to if I was representing a solvent company, I would just take that lying down. I would want to effectively push and make more of my cross claim and argue that the adjudicator's decision is going to be challenged. And what if perhaps I haven't chosen to defend in a kind of a way that allows the adjudicator to have examined my counterclaim? What if I've just defended against the claim? Or what if I have other claims under other contracts or in different areas? Perhaps I just don't deal with you in a building scenario. I deal with you in a, as it were, a non-adjudication scenario. Well, then basically the court's going to want to take all of those into account. And again, it's still going to want to preserve this security. And just to show that this is still, as it were, sort of a paramount concern, Lord Briggs, who gave the lead judgment, as we've heard in the Supreme Court Bresco decision, effectively stated the following: the liquidator may offer appropriate undertakings to ring fence any enforcement proceeds, and he refers to the case of Meadowside, which I'll come on to. He then goes on to say, where there remains a real risk that the summary enforcement of an adjudication decision will deprive the respondent of its right to have recourse to the company's claim as security for its cross-claim, in other words, it loses that right of set-off, then the court will be astute to refuse summary judgment. So it's still very much a live issue potentially. So I'm just going to take a look at Meadowside and the protections that Meadowside gave. Now, I've given you the citation of Meadowside in case you want to read the case itself. It is a good case, and it does give a good summary of a number of issues. I won't go into detail too much on the facts, other than to say that it concerned a JCT minor works contract, which did, under its mechanism, give, as it were, a net position. But the other important point here is that the funder of the litigation was basically an outfit called Pythagoras Capital Limited, and they've been behind a number of the recent cases in this developing field. So going back and sort of looking at what Meadowside said, Meadowside commented really, it was decided in between the Bresco Court of Appeal decision and the Bresco Supreme Court decision, so it's sandwiched. So Meadowside really looks at the Court of Appeal decision, and in that decision, Lord Justice Coulson basically said, as we've heard, that adjudication can go ahead, but enforcing that adjudication would effectively be the exercise in futility, no utility. But he did say that it could go ahead in exceptional circumstances. And what Meadowside does is it examines those exceptional circumstances where an adjudication, a summary judgment application, an application to avoid the stay of execution can be allowed to go ahead. And it basically set out almost a two-stage test, which I'll come on to. But just before I do, my point is, basically, Meadowside decided before the Bresco Supreme Court decision, but it's referenced in the Supreme Court decision. So it is potentially still relevant until we have further, perhaps, case law that smooths things out. So what were the Meadowside protections? What's the test? Well, broadly, it's two-stage. The first is that the adjudication, or the future potential adjudication, has to determine the net position under the relevant contract. If it doesn't, arguably, you're off to a bad start, and the court is going to look, in any event, at the total, as it were, mutual dealings between the parties. But my point is, you haven't satisfied test one, you're not dead in the water, but you are going to still have to perhaps go through more explanation to go forward. So the net position is crucial. The second point, and apologies, it says 3 in front of it, draft, apologies. The second point satisfactory security must be given. Now, in Meadowside, it broadly looked at security being given in three areas. One, in relation to the amount of the, as it were, enforced sum, the adjudication award. Again, going back to what I'm saying about the solvent party paying but not being able to recover, it suggested security should be given for the full amount of that award. It also said that it thought that the solvent company's costs of defending an enforcement proceeding and succeeding in it, in other words, the unsuccessful cost of the enforcement, should be covered. And finally, it said that any subsequent costs of the solvent company having to prove that the adjudicator was wrong and overturn its decision and effectively prove its own case should also be given security. So again, quite serious. What is satisfactory security will be decided by the court on the facts as to its form, duration, and amount. And in Meadowside, it effectively gave three examples, three suggestions, a combination of these. One, that the enforced sum was ring-fenced. Two, that, as I've said, a third-party guarantee or bond was given in relation to other aspects. And finally, after the event, insurance was put in place by way of top-up. So again, as it stands at the moment, that test is fairly onerous, and we're talking about significant sums. It's not a few £100s, it is going to be a few £1,000s. And in a case which we're going to touch on later on, Balfour Beatty versus Aztec, the figure that was put forward was £250,000. So I'm not saying that will be all cases. Hopefully it will be well manageable, but there is, as I say, this potential issue there, which I think as we go forward may be resolved with more case law and perhaps better sort of litigation funded packages. So what if the liquidator can't meet the Meadowside protections? Is it the end of the line? Well, how can he fund this? Well, just to touch on this, and again, some of you may be aware if you've litigated before, but I think there are four main areas. One, the liquidator could possibly tap up the other creditors of the insolvent company and see whether they wanted to go forward with the claim. They'd fund the litigation. Now, again, it's possible, but whether you as a creditor of an insolvent company will want to do that and, as it were, potentially throw good money after bad is a question. It does happen, but it's not in every case. The second alternative, or a combination of these, is to get your lawyer to basically go along with it and cover it under a conditional fee agreement where they would recover their costs from the other side with a markup, or under a damages-based agreement where they'd recover their costs from the other side and take a share of the recovered sum, the damages potentially, or the enforced sum. But again, lawyers are going to want to sort of make sure they've got a good case. They're not going to want to back a horse that's not likely to win. So again, there is some issue here. Litigation funders, as we've seen with Pythagoras Capital, may be first in line. Clearly, Pythagoras Capital are interested in this area, and basically, they stump up the cash to pursue it. But again, they're only going to, I think, want to back cases where they feel there's a really good chance of succeeding. And then finally, insurance. If you have, as an insolvent company, the benefits of a legal expense policy, you may be lucky in that it will operate if you're insolvent and you get your claim covered. Alternatively, you're looking at going to an insurance firm to give you after the event insurance. But again, you've got the issue in that case of being able to show you have a good claim. And by way of cover, as a rule of thumb, I think, again, no hard and fast rules, but £100,000 worth of cover has a premium of about a third, so £33,000. So again, these things aren't insurmountable, but it obviously depends on what's in play and what we're fighting over. It could be that the adjudicator's decision, if you have one, is sufficient to actually unlock a lot of this. You can use it as the key to get that funding, as it were, as the reason why you have a good claim. But I flag it in that it's kind of, something to think about. And as I say, I think going forward, we will probably see more tailored packages from insurance companies and litigation funders. Now, just to come on and go a little bit perhaps off the beaten track, one of the challenges in Meadowside was really in relation to champity and maintenance. Now, for those of you that don't know, traditionally under English law, it was wrong if you had a third party that was funding your litigation. It was seen as effectively what you could call litigation trafficking, third parties funding litigation to get a cut of it. And there are two main sort of, I suppose, phrases. Maintenance is where a third party supports a party in terms of funding their claim, but has no legitimate concern or interest in it. Champity is where they fund the litigation, but they take a cut of what's recovered. And as I've said, traditionally, for public policy reasons, those claims were challengeable and potentially illegal. But with the death of legal aid and the onslaught of conditional fee agreements and damages-based agreements, modern law recognises third-party funders as being legitimate, provided the rules that are in place, re CFAs and DBAs, are met. But if there's any sniff of impropriety, then arguably that funding arrangement can be challenged. Now, in Meadowside, it was challenged. Pythagoras were accused of effectively having a damages-based agreement which enabled them to recover more than 50% of the enforced sum of the damages. Now, that's wrong. Under the damages-based agreement regulations 2013, 50% is the maximum. And so this issue was brought before the court. Now, the actual damages-based agreement was not disclosed to the court in its entirety. And the court effectively said as a result of that, it couldn't really make a firm decision in relation to the particular issues. But what it did effectively say was that on the facts, it did look as if there was potentially some champitous behaviour. And it was one of the factors that the court took into account when rejecting the security that had been given by Pythagoras. So this is a bit of a double-edged sword. Some may take the view that it's better not to disclose a damages-based agreement and to basically work harder on the security to take things through as far as you can without perhaps that damages-based agreement getting in the way. But it is a risk, because obviously if you want to rely on it, it's found to be an issue later on, then you may find yourself being challenged at the last minute. And the court basically said, in terms of bringing the champitous proceedings, the issue wasn't so much that the proceedings couldn't be brought, it was more an issue between, as it were, the liquidator and the litigation funder. So again, we haven't really had too much guidance, but I think what we will see in this area is a lot more challenges, because I think, going back to what I'm saying, the circumstances are going to be such that I think there will be a significant there'll need to be a significant return to the party that's offering the funding. So based on that's likely to be something that perhaps opens up. But as I say, I think we're going to be seeing a lot more litigation and a lot better funding packages to perhaps tick the appropriate boxes, together with case law that clarifies. Now, going back to my extras, just a few things to touch on, housekeeping really. Section 108A of the Housing Grants, Construction and Regeneration Act states that you can have cost-bearing adjudications. Now, adjudications are going to need to be potentially funded by liquidators, and I think what we're possibly going to see is liquidators being quite bullish and trying to push for a Section 108 scenario in terms of getting both parties to agree that the costs of bringing the litigation, not just the adjudicator's costs, be awarded, as it were, by the adjudicator. Now, if the contract's silent on that, you don't need to agree to it. But I raise it just because I think if you're a litigator, it's a good way to kind of set out your stall and make the point that you're coming. And if you're defending, it's a good thing to just watch out for and say no thank you to. So that's Section 108A. On a side issue, Cannon versus Primus, which initially was decided with the Bresco Court of Appeal decision, basically states that companies in conditional voluntary agreements can, as it were, enforce. They're not the same as it were a company that's in liquidation. They are potentially still alive and active, and it's thought that that ruling will also apply to companies that are in administrations, or certainly administration pre dividend being called in those cases. So Again, I just highlight those as being effectively a different area, but I also flag that they are case sensitive. So in terms of getting security for costs or other issues, if you're on the receiving end, it would still be worth speaking to your legal advisor, hopefully me. Finally, just to touch on the Corporate Governance and Insolvency Act 2020, which came in on the 26th of June, deemed by some to be the biggest development in 10 years in insolvency. Broadly brought in really post the start of the coronavirus, and what it basically does is it gives a company that's in trouble or that's soon to be in trouble the option to seek a moratorium of 20 days initially from its creditors being able to bring a winding up proceedings against it. The moratorium can only really be put in place where the company is in sort of is rescuable, and the moratorium is likely to lead to that. It can be extended by a further 20 days to 40 days, and it can be extended beyond 40 days by court order. I flag this just because in terms of whether that type of company is viable or not may depend on whether there's an adjudication decision or an adjudication in the wings. So we may see some link up between moratoriums and this. And also, I suppose the other point to make is that Bresco is effectively in line with the government policy at the moment, which would appear to be to give companies that are in trouble a bit more of a breathing space or a bit more of an opportunity to live a little bit longer and fight on. So that is the Corporate Governance and Insolvency Act. That, thank you very much, concludes my talk. And I'll now hand you back to Peter to deal with the utility points.
Thank you very much, Graham. That's very interesting. I would say that there are other funding companies other than Pythagoras, excellent though they are. We're not just banging their drum. And if you are looking for funding, no doubt you will try all the options to see which one suits you best. Utility. Sorry, no apologies for quoting Lord Briggs again. In many respects, a fine judgment, and this is what he said about utility. Yes, adjudication was originally conceived to keep the cash flowing, and one of its important purposes is to enable the enforcement of a right to interim payments as a contract proceeds, to protect the cash flow of the contractor, subcontractor, whoever it may be. But he also goes on to say that adjudication is now very much part of the mainstream of ADR. It's one of the, in the construction field, it's the most frequently used means of dispute resolution. And despite the fact that it is binding only on an interim basis, as we all know, namely that if you don't like the adjudicator's decision, you can go and challenge it in arbitration or court as the contract directs. Anecdotally, and in my experience, I would agree with this, the vast majority of adjudicators' decisions are accepted as the final word in disputes. So even if people don't like it, they suck it up and move on, or maybe negotiate a different settlement on the back of an adjudication decision. So what the main point of what Lord Briggs was saying was that dispute resolution is, as I said earlier, an end in its own right, even if enforcement is unlikely, and that really underpins the decision on utility. You can't just say you're not going to be able to enforce the adjudicator's decision, so there's no point in getting it, because there are many uses to which an adjudicator's decision may be put when in favour of an insolvent company. So just to reiterate what Graham was saying, let's just have a look at some of the scenarios that have been that were considered by the Supreme Court. So the simplest one, scenario one, there's a claim under a construction contract but no cross-claim. In those circumstances, if you get a decision from an adjudicator on the claim that's favourable, there's no cross-claim, so there will be no need to perform any set-off calculation. and the construction, the enforcement of the adjudicator's decision will be possible, subject, of course, to the liquidator being able to offer the Meadowside protections, so ring fencing the decision money and providing security for costs of any litigation going forward. What might happen in practice here, of course, is that if the parties are sensible and if the adjudicator's decision is not out there as being perhaps subject to serious question or likely to be successfully challenged through the courts, they might negotiate a deal whereby some money is paid without the need for all of the Meadowside protections to be put in place, or indeed enforcement to be dealt with through the courts. And perhaps even in circumstances where the adjudicator has gone out on a limb and made a rather unusual decision by reference to the law, as sometimes happens, it might still be the basis for a sensible settlement negotiation, simply because nobody wants to get involved in expensive litigation where there is huge risk, particularly if there's more risk on one side than another, and also if there's risk on both sides. So let's move on. Scenario 2, a bit more complicated. So you have the construction claim, but this time you have a cross claim for a lesser amount, and that cross claim is not disputed. There you would adjudicate, get your decision on the claim, and if the responding party is well advised, they will refer to the cross claim in the adjudication as a potential defence to the claim that's brought, and the adjudicator will have to take that into account, and he will make a net decision on the amount due, which again can be enforced in the same way and circumstances as with scenario 1. Getting a little bit more involved now. What about where we have a claim under a construction contract and a cross claim that is not construction related, but it constitutes a potential defence? So it may be that there is a broad set-off clause in the contract that enables all claims going either way to be taken into account and set off against the claims under the construction contract. In those circumstances, then the the claim would be decided, and the adjudicator would make a declaration as to the amount due under the claim. But of course, the cross claim not being arising under a construction contract, he would have to leave that to be dealt with by other means. So he would make a declaration as to the amount due under the construction contract, and the set-off calculation would be completed when those other means were exercised to quantify the value of the cross claim and determine the amount due one way or the other. Scenario 4, if you have several claims under different construction contracts and several cross claims under the same or different contracts, then if the dispute is referred to adjudication, you have two issues to deal with. Firstly, you can only refer one dispute under one contract to adjudication. You can't refer disputes under several different contracts to adjudication unless the parties agree to it. So in those circumstances, try and get agreement. The pragmatic approach of the courts is illustrated by the Balfour Beatty and Aztec Projects case, which Graham mentioned earlier. In that case, there were Aztec had been carrying out a number of, I think it was 3 subcontracts for Balfour Beatty, and one of the objections that Balfour Beatty raised was that there were three subcontracts, and the disputes therefore couldn't all be referred to the same adjudicator, and the court said absolute nonsense. Although Balfour Beatty have to agree for several disputes under different contracts to be referred as one, in practice what that could be got round by simply appointing the same adjudicator to decide every dispute. So that is another instance, and we see it all the time, of how courts will back adjudication to the hilt, and they don't like clever black letter arguments, and will often find a practical way around them. So your several claims, you may be able to get them referred to the same adjudication by agreement, or if not, it's usually possible to get the same adjudicator to decide them all at the same time. And similarly, with scenario 2, if there are cross claims under those contracts, or different contracts, if there are wide set-off rights, then the adjudicator will have to take those into consideration. And the end result will be decisions which, with a little bit of maths, which you might need someone other than your lawyer to do if you want it absolutely spot on, you will determine the net amount due between the parties, thus finishing off the insolvency set-off calculation. And there you will have a decision that, if it's in favour of the insolvent company, could be enforced subject to the Meadowside protections. If it is, if that's the situation, going by the usual acceptance of adjudicators' decisions, then that decision will either form the basis of a successful enforcement with Meadowside protections, or a negotiation that avoids the need for enforcement and the expenditure of any more costs. So there we see a few concrete examples of how an adjudicator's decision can be useful, enforcement or not. It provides a platform for negotiation at the very least, and even where a cross-claim can't be determined by the adjudicator, it provides a means of quantifying part of the claims that make up the insolvency set-off. So useful, can be enforced under certain circumstances. Resolution of disputes is an end in itself. Assistance in the taking of an account to give effect to insolvency set-off. Declaratory decisions can be useful to trigger negotiation and settlement. Adjudication is a generally thought and is in fact a less expensive and quicker means of resolving construction disputes than going through the courts. The courts recognise this, and that's why they will back adjudication in the majority of cases where there is an issue with regards to enforcement or anything else, as in Bresco and Lonsdale, the fundamental right to adjudicate. So I will finish with a bit more of Lord Briggs. This is what he said about utility. There's no conflict between adjudication and the insolvency process. Just because there are cross claims, there is no reason why the statutory right to adjudicate should be denied to a liquidator. What we're going to see now is a different situation to what it was in the old days, if I can call them that, where one was faced with claims by an insolvent construction, claims by an insolvent party going into liquidation. You would generally just sit tight and hope that the liquidator wouldn't be minded to risk money litigating the dispute, and invariably that was the case. But after Bresco, adjudication definitely gives a liquidator a very useful tool by which to extract value from construction claims in the ways that Graham has just explained. So it is a brave new world. There will be strategies and tactics, no doubt, that evolve over time as disputes arise and the courts are asked to decide points. But do watch this space and think carefully about it. If you're a liquidator of a construction company with outstanding claims, seems to me there's a much better chance of getting some value out of them now than perhaps there was before. B, if one of your supply chain has gone insolvent, don't just think that you're not going to hear about it again. You probably will. And the main point of all this, which is where Lord Briggs and the Supreme Court is coming from, this is another reason to sit down and negotiate realistically and sensibly at the outset, rather than to let disputes evolve, run up costs and become more difficult to settle. So from Graham and me, thank you very much for joining us this morning, and I hope you found it useful. There is a recording available for anyone who had to leave early or missed it. So good luck with that. Distribute it to your colleagues if you think it might be useful. That would be appreciated. We look forward to seeing you on the next of our webinars in a few weeks' time. Thank you for joining us. If you have any questions, then please feel free to email Graham or me at your leisure. Thank you very much.
Thank you.